हेलो फ्रेंड्स, आज हम डिस्कस करते हैं अबाउट जुडिशियल रिफॉर्म्स इन इंडिया. व्हाट इज एलिंग आवर जुडिशरी एंड व्हाट आर द रेमेडियल मेजर्स? The biggest problem being faced by the Indian public is high pendency of cases in the various courts of India. Approximately 70,000 cases are pending in the Supreme Court. Almost half a crore, 50 lakh cases are pending in the 25 different high courts of India. And approximately 4.2 or 4.42 crores, almost 4.5 crore cases are pending in the lower judiciary. By lower judiciary, what we mean is the district courts and the subordinate courts. So such a huge high pendency creates problems for the public. Now, checking the pendency as per percentage, out of these total cases pending, approximately 12% are pending in the various high courts of India, that is 25 high courts of India, and approximately 88%, 87.4% exactly are pending in the lower courts. So lower court percentage is more and high courts is also significant. Another problem is the speed with which the cases are being resolved. The civil cases in India compared to Europe, they take 4 times extra time to be resolved. Presuming that one case in Europe takes 5 years, here in India it will take 20 years to resolve. Similarly, the criminal cases are even worse. In Europe, if it takes 1 year, here it will take 5 times more time, that is 5 years. Or if in Europe it takes 5 years, one case, here it will take 25 years to resolve. So the speed of hearing, the speed of resolving cases of our judiciary is also far too slow. You'll be surprised to know that almost 4.88 lakhs, almost 5 lakh prisoners are still languishing in the jail, and out of them, 75% are under trials. So even after waiting for 5 years in the jail, they may be acquitted. The average time of solving cases in India is very, very slow. The statistics say that 1450 days it takes each case to be resolved. That amounts to around 4 to 5 years one has to wait for resolution of a normal case. And Justice Markande Karju, as per him, he is a very prominent judge and a lawyer too. He is critical to the extent of saying that at this pace, at this slow snail pace, it will take 360 years, 360 साल लग जाएंगे for resolution of our cases, pending cases in the Indian judiciary. Well, you can imagine our grandchildren, our great-grandchildren will also not be there by then. What is ailing our judiciary? What are the problems being faced? The biggest problem being faced is the low judge to population ratio. Judges are very less compared to the population India has. Just imagine India has only 20.91 judges per million population. That is approximately 21 judges per million population. Australia has 43 judges per million population. Canada has 75 judges per million population. And look at US, 107 judges per million population. So obviously, there the pace of settling of disputes and decisions is pretty fast. We have to increase our judge to population ratio. Come down next. Further problems being faced by our judiciary. Of all the cases that are pending in the various courts of India, 50%, what I'm trying to say is, the government is the biggest litigant. Maximum cases are from the government side or against the government. And out of the total revenue cases pending in various judicial courts of India, 50% of the revenue cases are from the government side. So you can well imagine a large quantum of our money, which can be used for other welfare purposes, is stuck up in litigation for and against the government, and government has to take some proactive steps to resolve this. 4.7% amount of our GDP is stuck in litigations. Imagine if these litigations are resolved, this much of amount of our GDP would be released for development purposes. That amounts to around 5 lakh crore rupees being stuck in various litigations. And as we discussed, government is the biggest litigant. Government has to take some proactive steps, make the laws in a manner so the litigations are minimum, and resort to other means of resolving litigations. Any average in India case takes 4 to 5 years to resolve. In the lower court, it takes around 10 years to resolve. In the high court, approximately 2 years. These are statistics for your information. Additional problems with our judiciary is very, very poor budget allocation. 0.08 or 0.09% of the GDP is allocated to the judiciary. That is even less than 1% of the GDP. Obviously, the infra would suffer. And as a result, very poor infra for lower courts. If you have gone personally and seen the condition of lower courts, is really miserable. I've seen courts wherein there are no toilets. I've seen courts wherein the furniture is totally broken. I've seen courts, the judges sitting with a single fan in the midst of extreme heat of May and June. So the infra is pretty poor and they have to work for very long hours. There are heavy vacancies, almost 30 to 35% vacancies exist in the courts presently. You'll be surprised to know that in the 25 high courts of India, there are 400 judges vacancies existing. And in the lower subordinate courts, that's district and below, around more than 5,000 judges vacancies are pending and they are not being filled by the government. The reasons we'll discuss ahead. Another thing that is ailing our judiciary is the uncle judge syndrome. Uncle judge syndrome means relatives are pushing the interests of relatives ahead. The judges are relatives of judges. The new judges being recruited are relatives of judges. And this is as a result of the so-called collegium system. We have to find out a via media between the collegium system and the NJAC. That's a different topic altogether. We'll be discussing it in a separate video. The judges or the judiciary, Indian judiciary still enjoys colonial holidays. Almost 1.5 months of summer break and almost 10 days of Christmas break. This used to happen because earlier the colonial masters, the judges who were the uh, white-skinned Britishers, uh, they were not very comfortable with the tropical climate of India, and in the peak summers they would prefer to sail back to England or Britain. So they used to take long holidays. That's legacy is still continuing, and it should be rethought with the increasing number of cases and large pendencies in the Indian judiciary. It is proposed that at least 15 days of holidays of the judges are cut short. Our judiciary is averse to digitization and incorporation of ICT, information and communication technology. So this distaste for digitization has to go. More and more digitization has to occur so that the judiciary functions faster and better. Coming to the next slide. There has to be disincentive in flouting of laws. What kind of disincentive? In case there are disincentives, obviously the people would flout laws lesser. For example, eviction law. In eviction law, if there are heavy penalties for the people who are not evicting their premises on a due date, obviously they'll be wary of not evicting in time. The lower judiciary requires to be funded. The low rate of GDP, that is 0.08 per to 0.09%, which is being given to the judiciary as of now, has to be increased so that infra in the lower judiciary improves. Infrastructure has to improve. The quid pro quo which goes on in collegium system and the selections which take place behind closed doors have to go. The selection system of judges, the recruitment judges system of judges has to be more transparent and public friendly. Another way forward is the retirement age of the High Court judge is 62 years here. In Supreme Court, it is 65 years. We have to increase the age of retirement. You see, in America, the judges never retire. A judge is a judge for life. You will find very senior judges 80, 85 years still serving in America. Because judge is a specialized profession and the experience matters a lot. So long as he is healthy, he should be permitted to serve. However, in India, it is proposed that at least 3 years increase should be in the retirement age of the judges. We have to have intermediate courts of appeal. What's happening is the Supreme Court is being overburdened. The High Court cases which are not resolved are going to the Supreme Court. there should be an intermediate court established in 4 different geographical locations of India. What will happen is the High Court appeals will go to the intermediate courts instead of going to the Supreme Court, and Court can give attention to important issues rather than getting meddled with large number of appeals. Dual access and hybrid system. It means the public should have dual access. One is to the courts of laws of India, and second is the Gram Nyayalayas or the alternative means of dispute resolution. Alternative means of dispute resolution, which we will be discussing earlier. Usse, what will happen because of that is the number of cases which are piling up in the various courts of India will reduce. Increase the working days, as you have already discussed, those are enjoying far too long holidays. The logic being given by them is that they are doing a lot of brain related work and they require refreshing. Yes, agreed. But the colonial holiday should go, and at least 15 days of their holiday should be reduced so that the working dependencies can be resolved. There is another proposal, Indian Courts and Tribunal Service. This is a new service being suggested, that an additional administrative kind of a service should be introduced into the judiciary, which is Indian Courts and Tribunal Service. This service can take on the additional load of specific cases and to some extent the management part also. So because of that, what will happen is the load on judicial decisions on serving judges would be reduced. Alternate dispute management methods should be resorted to, like lok adalats and mediation, etc. There has to be inclusiveness in recruitment. What I mean by inclusiveness in recruitment is that the recruitment of judges should have adequate number of women representatives. Also, will be surprised to know that in the Supreme Court of India, as on date, till date, only 11 women judges have been there, and not even a single judge, the Supreme Court Chief Justice, has been a woman till date. So gender inclusiveness and backward class and caste inclusiveness also will make a lot of difference, because women would be able to listen to the woes of women or the problems of women better. Women are 50% of Indian population, and this small minuscule representation doesn't speak well of Indian democracy. We should hire professional court managers. The judges should not be stuck up with routine administrative work. They should be paying more attention to important judicial issues rather than administrative work. There are a large number of PILs which are hibernating. Hibernating PIL means the PILs which are waiting for 10 years, 8 years, 5 years, and even the first hearing has not been there. Pehla hearing ही नहीं हुआ है. Such kind of PIL should be squashed so that the load from the judiciary reduces. We should have a system of appointing ad hoc judges. Judges who retire could be appointed as ad hoc judges for resolving various pending matters. Article 2 to 4 of A of the Indian Constitution speaks about that, and this can be a good way of reducing dependency. So, gentlemen, we have discussed what is ailing our judiciary and what are the various problems that we are facing and what are the various ways forward. Thank you. Jai Hind. Jai Bharat.